Ever had one of those moments where you wonder if a tiny mistake could unravel a whole big plan? Well, today we're diving into a real-life legal dispute between a homeowner and his HOA that does just that. It all kicks off with a meeting notice sent just 45 minutes too late, and it ends with a verdict that might just change how you think about what a meeting even is. So this is the big question at the heart of it all. Does a 45-minute slip-up make an entire meeting illegal? Is it just a simple, harmless error, or is it a major violation of a state law that's there to protect homeowners? Let's get into it. All right, so let's meet the players. In one corner, you've got Robert Wolfe, the homeowner, and in the other, the Warner Ranch Association's Board of Directors. It's that classic homeowner versus HOA setup, but as you're about to see, the real story is all in the details.
Okay, so this whole thing, it really boils down to one very specific law, the 48-hour rule.
The entire case is hanging on this one statute, Arizona Revised Statute 33-1804D. Now, you don't need to be a lawyer to get this. Basically, this is the law that lays out the rules for HOAs on how, and more importantly, when, they have to let their members know about board meetings. And look, the law is crystal clear on this. It says notice shall be given at least 48 hours in advance. It doesn't say around 48 hours or give or take. No, it's at least 48 hours. And that very precise wording is exactly what gave our homeowner, the petitioner, his entire case. All right, so let's look at this from Mr. Wolfe's perspective. For him, this was an open and shut case. He believed the HOA broke that 48-hour rule, plain and simple, and he laid out his evidence in a really clear, logical way. This timeline is really the smoking gun for his case. Let's just walk through it. The notice goes out Wednesday at 1:45 p.m. So the 48-hour mark would be Friday at 1:45 p.m. Simple enough, right? But the meeting was actually held at 1 o'clock p.m. on that Friday. You do the math, that's a 45-minute gap. Based on the numbers alone, his case looks totally solid. But it wasn't just about the clock for him. He argued that this wasn't just some casual get-together. I mean, it had all the signs of an official board meeting. The notice had a formal agenda, with official-sounding items like call to order and establishment of a quorum. And later, the meeting minutes even confirmed that a quorum, that's the minimum number of board members you need to do business, was there. So he had the timeline and the paperwork. And during the hearing, Mr. Wolfe basically summed up his whole argument with this classic line. He's saying, look, it had an agenda. It had the right people there. It had official minutes. Come on. It was a board reading, which means that 48-hour rule had to apply. But just when you think this is a slam dunk for the homeowner, the HOA comes in with its defense. And you know what's wild? They didn't argue about the timing at all. Instead, they changed the entire conversation. Yeah, their strategy was pretty brilliant. They essentially said, you're right about the 45-minute gap, but you're totally wrong about what kind of event it was. They just sidestepped the whole 48-hour issue and went straight for the fundamental question. What was this thing really? So now you have these two completely different stories. Mr. Wolfe is seeing an official board meeting that's governed by state law, but the HOA, they're calling it nothing more than an informal meet and greet, which would have zero legal notice requirements. And the HOA brought facts to back this up. They testified that the whole point of the gathering was just to introduce everyone to their new management company. In fact, it was the new company that set it up, and this was before their contract even officially started. But here's the most important part. They insisted that no actual HOA business happened. No motions were made, no votes were taken, no decisions were finalized. It was all just talk. So what do you do with that? You've got two totally different views of the same event. One is all about following the rules of procedure. The other is about the actual purpose of the gathering. So how did the administrative law judge sort this all out? Well, in a twist that I think is pretty surprising, the judge didn't get hung up on that 45-minute timeline that seems so important. That whole issue about being late with the notice, turns out it wasn't the deciding factor at all. Instead, the judge really leaned into the HOA's argument. The decision focused almost entirely on the substance of the event. What actually happened in that room? Was any real business conducted? That became the only question that mattered. And this one sentence from the final decision says it all. The judge declared that this so-called kickstart meeting was not, legally speaking, an HOA board meeting because no HOA business was actually done. And the conclusion from that is huge. Because it wasn't an official board meeting where business was conducted, the 48-hour rule just didn't apply. So all that stuff about the timeline, the agenda, the quorum, none of it mattered in the end, because the judge decided the event itself wasn't what the petitioner claimed it was.
So, the final outcome? The petitioner's case was completely dismissed, and to add insult to injury, he was ordered to pay the $500 filing fee for the petition. It was a clear, decisive win for the HOA.
Okay, so what's the big lesson here? I mean, this is a very specific case, but there's a much bigger principle at work that's really worth thinking about.
It really comes down to this idea of substance over form. You can call something a meeting, you can write up an agenda, you can get everyone in the room, but if you don't actually conduct the business of a meeting, make decisions, take votes, then the law might not see it as one. What you do is so much more important than what you call it. Which brings us back to that first question, when is a meeting not a meeting? Well, this case gives us a pretty clear answer. It's when no actual business gets done. It's a fascinating reminder that in the world of rules and law, the purpose behind what you're doing often carries a lot more weight than the label you decide to stick on it.